Should I tell Stacey to change her audio?
Can you hear me, Caroline?
Yeah, can you hear me?
Yeah.
Rob recommended changing the audio to the computer.
I think
E243 for the microphone.
May already be set.
Maybe.
Yeah.
Hello, ladies.
hi.
Just want to let you know I can hear your audio and video is good. We're good to go. We can start at 11. I'll hop off. But if anyone has any questions, type them in the chat box, and I'll be moderating the chat box.
Are either of you guys getting echo, or is that just me?
I don't have any echo, Caroline.
Okay, might just be me.
I think maybe if one of you talk, the other one can go to mute. I don't know if you guys will be presenting together, but that way it'll help with the echo. All right, happy Friday, everyone. Like a little dance or something. All right, ladies, I'm gonna hop off. I'm looking forward to the session.
Thanks.
Caroline, should we go ahead and start? You want to give people a few more minutes to join?
Yeah, let's maybe give people one
Or
more
so.
minute. I think it's 10:59, so we'll let people be on time or fashionably late.
Well, we have a lot to cover, so maybe we'll go ahead and get started and jump right in. So welcome to Data Privacy Contracting Basics, our super exciting title for you today. For the presentation, my name's Stacey Shadden, and I am an attorney at McGrath North in Omaha. I split my practice kind of into two different subgroups, mergers and acquisitions, the main focus subset for me, mostly in the technology space, but I kind of dabble in every industry. And then I spend the rest of my day, and actually most of my day these days, on privacy issues. a whole host of things from helping clients implement and manage their privacy programs to various regulatory components, compliance with laws, if there's a data incident or kind of the management and mitigation piece, all the way up to complying with new regulations, GDPR, CCPA, and various state rules that have come out. And then I work very closely with my colleague, Caroline Nelsen. I'll let her introduce herself.
Yeah, so my name is Caroline Nelsen. I am an attorney at McGrath North as well. I partner with Stacey. I'm kind of started my practice as an employee benefits attorney focusing on health and welfare matters. And because of that, I started gaining more and more access to HIPAA issues. And through my work on HIPAA compliance for group health plans, I actually started kind of focusing on HIPAA privacy and data security, and through that work, found a great partner in Stacey. So we kind of tackle issues. I'll do the health privacy issues, and she'll kind of handle all of the other privacy issues. And it's really formed a great partnership. So not only do I do HIPAA and health data privacy for group health plans now, but I also do it for healthcare providers, for vendors to healthcare providers and health plans, third-party administrators, any sort of business associate. And so that's kind of what my portion of the presentation will be on today. And I'll kind of go over some of the goals for the presentation today. What we're looking to do is try to give you guys just a base understanding of data privacy laws that are commonly affecting technology companies specifically, including GDPR, HIPAA, CCPA, and other US federal and state laws. And then we're going to try to build on that base knowledge of privacy laws and apply it to negotiating contracts and understanding the different contract provisions that are commonly negotiated and that have kind of significant importance for tech companies that are entering into those contracts. And then, of course, we want to go over the importance of getting the correct contracts in place before you ever use, access, maintain, or store any data. So that's kind of the goals for today, and we do have a lot to get through, so I'm going to hand it back to Stacey and let her kind of give you an overview of the key data privacy laws outside of the HIPAA world, and then I'll give you a little insight into HIPAA.
Yeah, thanks, Caroline. So generally, starting in the US, there's no overarching kind of federal rule that's going to apply to everybody, and the collection of personal information from various individuals the same. We have industry-specific rules at the federal level, GLBA with financial institutions, HIPAA, which Caroline will talk more in depth with, that protects the protected health information in the health industry. And then you have federal rules that apply to various actions, COPPA with respect to children, CCPA with text messaging and telephone communications, spam on your email marketing. So, you don't have that one kind of comprehensive rule in the US at the federal level that applies. You do have the Federal Trade Commission that's out there at the federal level to kind of regulate privacy in general, and they do that through a lot of policy initiatives and education of consumers. But again, no overarching rule. And then each state at the state level has a state data breach law. We'll talk about that a little bit more in depth. And then we've seen recently a lot of activity at the state level with respect to privacy rules. CCPA has come out in the last year, become effective in the last year. There's the new CCRA that'll come out and change things again in California, and then other various state rules that have come out. Then you see on the international level a lot of changes, a lot of growth really to that comprehensive one data privacy rule that's going to apply to everybody with respect to the collection of personal information. Most notably, we saw that with GDPR, the General Data Protection Regulations in the EU, but you are seeing it. Brazil will be coming out with one that will be effective in the spring, I believe, and then you have China, who's announced and recently published some of their new changes. Canada's had one for a while. GDPR was one of the first that we saw that really did that extraterritorial effect, pulling in a lot of US companies that otherwise weren't subject to those privacy rules. So we'll start off with an overview of GDPR, because I do think it's important to understand the rules that a technology service provider or service provider in general is subject to if GDPR applies. So GDPR is that comprehensive set of data privacy rules that really pulls in, rights for data subjects to access or delete or have control. Really, it's all about control over their personal information and how it's used. It's effective on May 25th, 2018. It really applies to, we're just talking about And I generally say EU residents, although that's not necessarily 100% accurate because it's a little bit broader than just the EU nations. So it was designed to empower those data subject rights and implement technical and organizational safeguards. So there are security requirements with respect to GDPR that if it applies have to be met. So a lot of the first question I always get, I guess, from my US-based clients is, I'm a US-based company. I have no connection to the EU. I don't have offices there. Why does it apply to me, or how could it? And there's two kind of other prongs where GDPR would apply to a company that's based in the US, and that's if you're offering your goods or services to EU residents, you're marketing with an intent to gain customers over in the EU, or you're monitoring the behavior of EU residents. That's very broad. So it can be things like tracking persons that are operating through your software, or maybe just through your website online, and then using that tracking information that's collected to do behavioral analytics on it, or to profile persons in order to improve your software, your technology, or improve the functions on your website. So if you are doing that, even without the intent to be doing it for EU residents, but IP addresses that are picked up or other personal information that's picked up are from EU residents, then you can fall under GDPR really easily. GDPR also applies to both the collector of the information, so the person or the company who controls the means by which it's processed, but also to the service providers, the data processors is what it's called under GDPR. The persons who perform processing activities, whether it's transmitting information, simply accessing it, hosting it, storing it, performing some other process on the information on behalf of the controller. Key takeaways. Unfortunately, the US doesn't have that overarching federal rule, so we have been deemed as a country that doesn't have adequate security protocols in place in order for EU resident information to be exported into the US or to a company that's located in the US under GDPR. So a company that is going to be receiving that information as a service provider has to have some other mechanism in place in order to receive the information. That used to be very commonly with technology companies with the Privacy Shield. Trump 2 most notably came down and found the Privacy Shield was no longer an adequate tool to use under GDPR. So most technology companies now rely on the standard contractual clauses. Other things to keep in mind, data mapping is key. Understand what information you're collecting, who it's coming from, who you're sharing it with, so that you can understand what liabilities you have under GDPR. There are high penalties. I won't go into details on those. Very important to understand that they're out there and what liability risks you can shift to the controller or the processor depending on what role you play. And you can do that contractually with a data processing agreement, which we'll get into a little bit more detail later on, but is contractually required under GDPR that there is that agreement between a processor and a controller. So having that in place and then negotiating those terms properly in order to shift the liability is key. So that's our overview of kind of internationally GDPR, which kind of sets the framework for a lot of other countries that are following suit. So we'll come back to the US now at the federal level and let Caroline talk us through HIPAA. Oh, Caroline, I think you're on mute.
That happens to me way too frequently. So where I always like to start when it comes to HIPAA is, who does HIPAA apply to and why do I have to worry about this? When people hear HIPAA, they typically think, well, I'm not a healthcare provider, I'm not a doctor, I'm not a physician's clinic, I don't have to worry about this. When in fact, HIPAA is a very overreaching law. It actually reaches not only healthcare providers and any health plan, so any health plan sponsored by any employer, and then it reaches all of the service providers and vendors to those entities. And so it's really important to understand that HIPAA actually ends up impacting a lot more people than you think and a lot more entities than you think. So what I always like to say to companies that aren't in the healthcare industry but might have health data is, anytime you have anything that might look like health data, stop and think about HIPAA and try to analyze whether it applies to you. And so what is HIPAA generally? Generally, for a tech company, what they need to worry about is it has a privacy rule and it has a security rule. And these privacy and security rules lay out what is protected health information, so what type of data do I need to worry about? What type of administrative, physical, and technical safeguards do I have to have in place? What types of agreements do I have to have in place? What are my liabilities? and how do I respond to a breach of health data? And so these privacy and security rules really lay out how every entity covered by HIPAA can protect PHI in accordance with the law. And so I go back to that misconception about who HIPAA applies to, and I want to talk to you about who is a covered entity and who is a business associate. So HIPAA applies to what's called a covered entity. A covered entity, like I said, is a health plan, a healthcare provider, or a healthcare clearinghouse. With respect to a health plan, that actually means any health plan that's sponsored whether by an insurance company or by an employer. So for example, if you're a tech company that provides a wellness app, and that wellness app administers a wellness program through an employer's group health plan, you might now be maintaining data that is part of a health plan and is covered by HIPAA. So any employer that sponsors a health plan is responsible for that health plan's compliance with HIPAA. And then any vendor to that health plan, for example, a wellness app, could also be subject to HIPAA and could be receiving, storing, maintaining data that's protected by HIPAA. HIPAA also applies to what's called a business associate. A business associate is a vendor to any covered entity. So that's kind of where HIPAA is applying to most tech companies. So whether you're a cloud service provider, an app provider, there's a host of entities that are providing services to a covered entity, whether it's a healthcare provider, health plan, healthcare clearinghouse, that are then under this business associate definition and are subject to HIPAA. Now, what does it mean to be subject to HIPAA? What it means is that you have to have HIPAA policies and procedures that are compliant with all the standards for protecting protected health information. You have breach response obligations. So if health data is breached or is suspected to be breached, you have to comply with certain breach response timelines. You have to provide certain investigative reports to the covered entity on what data was breached and lots of other details. And you're also responsible for entering into what's called business associate agreements, which we're going to talk about later. So how do you identify what is health data that's covered by HIPAA? HIPAA says that you have to comply with all the obligations under HIPAA if you are maintaining, storing, using, accessing, or even have the opportunity to access what's called protected health information. PHI is individually identifiable health information maintained, stored, used, or accessed in any form. So electronic, paper, or even verbal. And so, for example, I like to think of this in the tech company world. If I were talking about PHI right now, this video storage would be subject to HIPAA, right? So even if I have a phone call with Stacey about a certain client's PHI, that verbal communication of PHI is also covered by HIPAA. HIPAA then goes and lays out the different permissible uses and disclosures of PHI. So when you can or cannot use and disclose it, if you are a covered entity or business associate and you have the correct agreements in place. Like I said, it has the breach notification rule, which outlines some obligations if you do have a security incident or a suspected breach of health data. And then there are fines and penalties for non-compliance. So later on in the presentation, I'm going to go over how this really impacts tech companies. I know it's kind of weird to talk about it in this context, but we are going to apply this to you and discuss the business associate agreement and what that means and how you can contract away some of the liability under HIPAA if you are using, accessing, storing, or maintaining protected health information. So I'm going to hand it back to you, Stacey, and let you go ahead and go over CCPA.
Great, thanks, Caroline. So, now that we have that federal understanding of HIPAA, which really is kind of one of the base privacy rules in the United States at the federal level, if you're subject to HIPAA and some of these other rules we're talking about, compliance with HIPAA and especially some of the security and the breach response rules that HIPAA sets forth allow you to also comply with some of these other rules pretty easily. So it's really important to understand HIPAA and its application if it applies to your organization. So CCPA, the California Consumer Privacy Act, it was passed in June of 2018 and became effective January 1st, 2020. Really changed the landscape in the United States if you do business in California. It does protect California resident information, so we're only talking about entities that are for profit. Again, if you're a nonprofit, I'll do a little side note. Nonprofits have kind of unique privacy rules that apply to them. A lot of the rules, even at a federal or state level, may apply differently to a nonprofit. So always important to understand whether or not, what rules apply to you. So CCPA, we were talking about just for-profit businesses that do business in California, collect that California consumer personal information, determine the means by which it's processed. So you're the controller of that information. I will say there are rules that apply to service providers. In particular, I have a lot of technology clients that are, technology service providers that are subject to CCPA and its requirements because of the way their software collects information or hosts information for their clients. And then you have to meet a certain threshold. So either 25 million annual gross revenue worldwide, not just in California, or there's thresholds for the amount of data that's collected from California residents that you could trigger, or if you sell personal information of California residents, there's another trigger that you could meet there to get subject to CCPA. So if you are subject to CCPA, there are very specific data subject rights you have to provide. Again, access and deletion of information, similar to what we saw under GDPR, although the processes, the procedures, the way you notify individuals is different than under GDPR. So I always, one of the first things I say when I have a new client that comes in under CCPA is I'll ask if they're subject to GDPR, if they've gone through that process in order to get compliant with GDPR, any of the other privacy rules that are out there, because compliance with those rules doesn't necessarily satisfy the rules and requirements for CCPA. You have to provide notice before you collect any California information, and you can do that. If you're collecting it online, you can do it through your online privacy policy. If you're collecting it offline, you do have to provide that notice prior to collection. So if you have employees in California, employees are subject to CCPA if you meet the thresholds, and so you would have to provide them very clear disclosures. The regulation actually sets forth exactly what the content needs to be in those notices prior to collecting any of their information. So at the applicant stage, you should be providing that notice. CCPA also has very high penalties associated with it. It's enforced by the California Attorney General's office. But one of the things notably that CCPA did that is changing the US landscape with respect to privacy rules is that it implemented this private right of action with respect to a data incident. So now if your company, knock on wood, has a data incident that contains California resident information, they no longer have to prove damages or prove harm. Each California resident that was affected automatically has a dollar amount assigned to them, a dollar amount that they get. So this is new. It's changing the privacy realm a little bit here in the US. We have seen that same private right of action with specific types of information, which we'll talk about in a little bit. But this is the first time we've seen it overall where no harm has to be proven. As I mentioned, the restrictions are similar to GDPR, but they're different for technology service providers, which I think is key to note here. We talked about the data processing agreement that GDPR requires with respect to a data controller and a data processor. Here under CCPA, that requirement doesn't exist. It does require, in order to qualify as a service provider, to have an agreement with a collector that governs kind of confidentiality restrictions, the ability to use, disclose, and retain California resident personal information. But as long as you have that standardly in your contracts with your customers, then you automatically can qualify as that service provider. What that does is it limits your liability if you're not the actor that causes the harm. So, you don't do anything wrong. You don't know that your client, you have no knowledge of your client's wrongdoing. Maybe they didn't provide the proper notices. Maybe they didn't have the proper rights to collect the information. And you as a service provider have mitigated that risk by qualifying as a service provider and have a safe harbor with respect to your liability. One of the other things that CCPA did, there was a new trigger. If you do sell information, you're a data broker, and sell is very broad. So it's really the sharing of information with a third party in exchange for some consideration. There's arguments out there whether some of the target or behavioral advertising that's occurring, some of Google's programs that they have, whether that could be a sale under CCPA, and it's kind of been left open for interpretation so far. But if you do trigger the do not sell kind of requirements under CCPA, there are very specific rules that you have to follow, things that have to be on your website, or abilities for people to opt out, and special notices that have to be provided. You also have to have very specific procedures in place with respect to California residents making requests for their rights to access their information or their right to delete their information. There's specific timeframes and specific processes for verifying people are who they say they are. So again, it is similar to GDPR, but I just wanted to emphasize, if you or your company have gone through some of the other reviews of the different rules and regulations that are out there, CCPA is different. The other thing I would note is there is the new CCRA, which is CCPA point 2, a lot of what people are calling it, that was part of the ballot initiative just a week or so ago in California. It was passed. So it will be enacted, and come January 1st, 2022, we will have new rules with respect to how both CCPA and the new CCRA will come into effect, and it creates new categories of information that have to be protected, creates new data subject rights in California for California residents. It almost brings CCPA a little bit closer to GDPR, although it's not going to be exactly the same. And so really interesting what California is doing on its own, as it's seeing no movement at the federal level with respect to kind of that overarching federal law that we talked about in the beginning. So now that we have an understanding of kind of CCPA, which is really the landmark rule out there in the US, we did want to just touch on some of the other state law rules that are out there. Every state has a state data breach law. It governs the process when there is a data incident. Some states it only requires, one person's personal information to be affected, and there's requirements with respect to individual notices and notices to the Attorney General's office for that state. And it, sets forth in a lot of details the rules with respect to notification and the content of the notices. There's also state biometric data laws that are out there. Illinois has had theirs for over a decade. It does also have a private right of action, so those individuals can bring suit under Illinois' laws. And there's numerous states, Texas, Washington, various others that have also enacted biometric data laws that protect information. Fingerprints, DNA, retinal scans are kind of the information that, or the type of information that's most commonly going to be protected under those rules. The other type of law that we're seeing pop up everywhere are your artificial intelligence laws. They are popping up in various states, and we're seeing movement through legislations with respect to those laws. So that is kind of our overview of some of the basic privacy rules that when you're contracting and going through the basics of contracting, you want to keep in mind in order to be able to evaluate how the rules, the contract rules, the provisions in the contract apply to you, and what your risks are with respect to contracting with various partners. So I'm going to kick us off in our contracting overview. So now we're going to take those rules, we're going to apply them, and I'll talk mostly about terms that you would see kind of in your master agreement, whether it's your on-prem license, whether it's your SaaS agreement, or whether it's a blockchain service agreement or some other master agreement that you'd be entering into. The first provision that my clients always take issue with and find that they're negotiating the most is a kind of a combination of their indemnity and their limitation of liability provisions. And so with respect to their indemnities, infringement was always the big one, right? Tech companies have been dealing with that forever. Do you agree to indemnify for infringement? Do you not? It's definitely taking a swing that that's just something that's accepted, but in the tech world that you would indemnify for infringement. But what about the rules we've been talking about? Compliance with laws with respect to data privacy issues, or a security issue, a data incident, for example. Are you going to protect your customers against those? Are you going to indemnify for them fully? That's a great question, and something that's definitely still a negotiating point right now. And then really key to remember, if you agree to indemnify for breach of agreement, you're agreeing to indemnify for every clause in the contract. So anything you breach, including all of your security or all of your data incident response provisions that you include in your agreements or your customers request in those agreements, you're agreeing to indemnify for that. So the first key is always to understand what liability are you taking on. And then from there, you can talk about how can you mitigate that liability. You can use your limitations of liability, your cap, and your damages waiver to limit that liability as fully as possible. So key things there, are you going to agree to any carve-outs to your cap? Is your cap essentially just a dollar, a percentage of fees, maybe 12 months, a 24-month fee? or is it a dollar amount, something greater, a super cap is often a terminology that's used for them. Then what carve-outs are you going to accept? We talked about infringement. That's often something that's going to get carved out, and people we're commonly seeing that, but that's just offered up. But what about your privacy-related carve-outs? Are you going to agree to uncap liability for a data incident, for example? A lot of people will try to tie those caps to their insurance amounts that are out there. But in a data incident scenario or a security scenario, it's very common that you're going to have multiple customers, multiple clients that are impacted by that event. And so if you cap it at insurance for everybody, you're going to run out of insurance if the damages are greater than your insurance amount kind of aggregated. And so you really want to keep in mind that while everyone always asks, what's your insurance, what's your cyber insurance, what amounts and policies do you have out there, those are to protect your organization as a whole and not an individual client. So, to the extent that you can do a super cap, that's something that makes sense with respect to the liability you're taking on, and the mitigation is always key. The other thing to keep in mind is there's the damages waiver is the other piece of the limitation of liability. If you read contracts as often as I do, you see it as neither party will be liable for consequential, indirect, exemplary penalty type damages. So those types of damages often relate back to the types of damages of a data incident. Notification requirements, credit monitoring, those things are often going to be categorized by courts to be indirect damages. So if you start accepting waivers or carve-outs to your damages waiver, you carve out a data incident, you've all of a sudden taken on additional liability that you wouldn't have had before if you kept no carve-outs from your waiver. So little things like that to keep in mind. What does your damages waiver cover? Sometimes you'll see loss or unavailability of data, loss of revenue, loss of reputation. Those are really key provisions that I recommend all of my tech service providers read very carefully to understand what liability they're taking on and how they can cap or reject carve-outs to their liability in order to maximize kind of their position overall with all of their customers. If you're working off your own form paper, making sure that those provisions are as strong as possible in order to protect you. The other key area with respect to our privacy rules that we talked about are the security provisions. Are you going to get away with kind of broad statements, that you'll comply with reasonable security standards, or that you'll comply with industry standards or administrative and technical safeguards? GDPR, HIPAA, which Caroline will get into, they do have very specific security requirements. And so, it's not uncommon to see customers, they're getting smarter and smarter. And it's not uncommon to see them start putting in very specific requests with respect to what levels of security have to be in place. The next option you can take is to try to get away with just saying, we'll give you a copy of our audit. If you get a SOC 2, if you get an ISO, or some other annual audit report, giving them that summary page that shows kind of how great you are. Sometimes you can get away with that. We're saying I have written policies and procedures in place. I have, a business continuity plan or an incident response plan, and I'm going to comply with those. Sometimes that will get you there, but we have customers more and more that are asking for specific audit rights. They want to do penetration testing, all sorts of different levels in order to ensure security, especially when you're talking about very sensitive personal information, or when GDPR, HIPAA, CCPA, or any of those other rules that come with high-level penalties get involved. You start to see those requests really go up. Another thing to consider is the ownership and the use of data. We've talked about what's personal information, what's not, whether you can de-identify or anonymize data. A lot of tech companies these days, a lot of clients in general, not even tech companies, are taking data and doing great and amazing things with it, but they're finding that contractually people are restricting those abilities further and further. You want to make sure you read those provisions carefully. If you're on your own form, you want to make sure that you are expanding those provisions adequately in order to give you the rights to do things with data that you want to. Even if it's in a de-identified or an anonymized data, or what feedback people give you. Can you do things with the feedback? Do you own it? Who owns, you have tracking information through your software, and you're collecting information that way, IP addresses, maybe usernames. Who owns that data, and what can you do with it? We're finding more and more that a lot of customers or a lot of our clients are getting restricted by customers saying, you can't do anything with our data, even if you de-identify it, and they won't let you touch it. And so that's a huge negotiating tool to use in order to ensure that you're not getting stopped by customer contracts in order to really do things from an analytical standpoint that further and better the software. The last point I talk about warranties. They're always a big one, but from a privacy standpoint, we talk about compliance with laws. And are you going to agree to comply with all applicable privacy laws? Can you agree to that? Is that something contractually you can agree to? And then going back to your indemnity, are you going to indemnify your customer for breach of those compliance with privacy law matters? And so really key things to think about as you're negotiating your contracts. I will say one point before I kick it off to Caroline for business associate agreements. I've mentioned a handful of times the data processing agreement that's out there. While GDPR does statutorily require that a controller and a processor enter into a data processing agreement, we're seeing more and more that customers or even tech companies are pushing down data processing agreements to everybody. It is just an addendum now to the master agreement. It covers off GDPR, it covers off CCPA, it covers off any other international law that may apply, and it just pushes everything down. The problem with that we're running into is our tech company clients are getting the bulk of these kind of compliance issues pushed down or flowed down to them when they maybe don't apply. So carefully reading that contract in order to understand what applies to you. If all of a sudden you're being held to a GDPR standard when GDPR doesn't apply to your company, that's putting a whole new risk of level of security, data subject notifications, and different items and policies and procedures you have to have in place if you say you're going to comply with the terms of GDPR when it doesn't apply to you. I mean, it's not necessary, and it's usually an easy tool to kind of push back on that customer and get rid of it. So really understanding what you're agreeing to is very, very important. So I will kick it over to Caroline for her to go through business associate agreements.
So I'm going to talk about business associate agreements, and as I kind of mentioned before, BAAs or business associate agreements are actually required under HIPAA. So the agreement has to be in place prior to any data being stored, maintained, accessed, used, disclosed, shared, whatever it may be. And so it is really important when you enter into a new relationship to understand upfront, am I or am the entity or is the entity I'm entering into a relationship with subject to HIPAA? Because that's going to drive whether you need this BAA in place. And you cannot make a BAA retroactively effective. It can only be prospectively effective. So you have to get it at the beginning before any data is shared, which is why it's so important to understand when HIPAA applies to you. So if you are a covered entity, healthcare provider, health plan, or healthcare clearinghouse, or if you're a service provider to a covered entity, a business associate, or if you are a service provider or vendor to a business associate, what's called a subcontractor business associate, you could be subject to HIPAA and you might need a business associate agreement in place. What HIPAA says is that you need reasonable assurances that a business associate or subcontractor business associate will comply with HIPAA and the terms of the BAA to the same extent that the covered entity complies. So your analysis really has to start with, am I contracting with a covered entity or business associate, one, and two, through those services, am I or may I need access to protected health information? Once you've identified, yes, I'm working with a covered entity or business associate, and yes, I may or may not need access to protected health information through the services that I'm providing, that's when you're then going to get the BAA in place. The BAA will delineate responsibilities between the parties. It will specifically identify what data is covered by the agreement. It will specifically lay out what you can and cannot do with that data when it's in your possession. It'll specifically lay out how you terminate the agreement and the destruction process of the data, the protected health information. And then it'll also lay out a few other key provisions that I want to walk through, because while the permissible uses and disclosures for the most part are regulated by HIPAA, the law, there are some negotiable provisions that end up being really key provisions if a breach were to occur. And so the first one I want to talk about, which is the most important in my opinion, and which Stacey also covered first in her portion, is indemnification and limitation of liability. HIPAA fines and penalties are very, very high. You can also get governmental penalties and individual notification costs that could come up. So if there's a breach, you have to notify every individual. You might have to notify state's attorneys general, like Stacey mentioned. You might have to notify the Department of Health and Human Services and Office of Civil Rights. You might have to provide credit monitoring to participants that were impacted. There's a number of expenses that really start to add up if there is a breach or a suspected breach or a security incident of any kind. So the first thing you want to do when you get a BAA or you're sending a BAA is you want to check that indemnification and limitation liability provision. Oftentimes, you won't find one. And what that means is that your BAA will likely be subject to the master services agreement with that entity that the BAA is related to. Sometimes you'll see the BAA actually as an exhibit to the master services agreement. Other times it'll be executed as a standalone document. And when it's silent, the argument will be, well, this is standalone. Is it really connected to this master services agreement limitation of liability, or is it separate and apart and it's silent and there's no responsibility that's been delegated to either party? Other times you'll see a separate indemnification or limitation of liability provision in the BAA. And depending on who drafted the agreement, you'll either see a specific, we will not indemnify, or if the covered entity or the business associate drafted the agreement for the subcontractor, you'll see really, really hefty provision here. It'll be unlimited, uncapped liability for the contracting party, usually with itemized expenses. So it'll specifically lay out government fines and penalties, individual notification costs, credit monitoring costs, setting up a hotline and call center. All of those costs will be actually itemized in the agreement. So you really want to make sure you're looking at that provision and saying, okay, what am I really liable for here? And do I need to negotiate this? Sometimes you'll actually even see in the master services agreement, I just want to point this out, in the master services agreement, sometimes you'll actually see a carve out for HIPAA. So you want to be careful with that too when you're negotiating the master services agreement outside of the BAA. Read that carefully and see if the caps on liability actually carve out HIPAA violations. It's another common thing you'll see because the costs associated with HIPAA violations are so high. The next key provision I wanted to talk about, which Stacey slightly touched on as well, is the de-identification of data. HIPAA actually allows you to negotiate this provision. HIPAA lays out certain standards for de-identifying PHI, so you do always have to comply with those standards if you will de-identify data. But oftentimes a covered entity or business associate contracting with a subcontractor will specifically prohibit an entity from de-identifying data. And that can be a huge issue for a lot of entities because most entities do de-identify data and use it for analytical purposes to improve the quality of their services. And so most of the time, that's an impossible provision to comply with. If you are going to be held to comply with that provision, you're going to have to actually separate out that data and make sure it's not commingled with all of your other data that you're collecting. And that can be a really big burden. So you do always need to check the de-identification of data provision. Another thing that I've seen is that sometimes companies will say, well, you can de-identify data only if you submit a proposal for a de-identification and it's approved by us. And that's another hurdle that IT departments just are simply not going to be able to comply with. And even then, you could, put this whole proposal together and prove that you'll comply with de-identification standards under HIPAA, and they just reject it. And then you still can't de-identify. So you really want to make sure that you do always have the ability to de-identify data and explain clearly to the entity you're contracting with to say, we de-identify in accordance with HIPAA. We have HIPAA policies and procedures in place. We have to have the ability to de-identify for, quality assurance purposes. And typically that'll allow you to go ahead and de-identify. I mean, HIPAA does not actually cover de-identified data. Once it's been de-identified in accordance with HIPAA standards, it's no longer protected health information. And so do always check that provision. The next big one I want to talk about is the timelines for breach and security incident reporting and other reporting requirements. under HIPAA, the maximum time period allowed for reporting a breach or security incident to the covered entity or the business associate, and then for the covered entity to report to an individual that was impacted, is 60 days. However, the Department of Health and Human Services has made it very clear that that is a maximum, and really no one should be waiting 60 days to get this done. You will see in a lot of business associate agreements, people requiring a much shorter time period for reporting, and so you do always want to check. I've actually seen some contracts written where you have to report within 24 hours, and I'm just going to tell you right now that that's impossible to comply with. The standards for the investigative report and the information that's required to be reported are pretty extensive, and 24 hours is not enough time to be able to fully investigate a breach or a suspected security incident within 24 hours. That's just not going to happen. So, what I typically recommend is if you're a business associate or a subcontractor to a covered entity, try to go for that 60 days. Because that gives you the full 60 days to comply, and just simply say, that's what HIPAA requires. If you need to, you can negotiate it down to 30 days, possibly even 15 if they were one of those 24-hour contracts. But any less than 15 days is going to be pretty difficult to comply with, depending on the size of the breach. Some other ones that I wanted to kind of call out are policy and procedure requirements. Some business associate agreements will actually require you to have policies and procedures, which some tech companies just can't comply with if they don't have specific HIPAA policies and procedures. So be on the lookout for those. Some BAAs will have insurance requirements. Some will require the business associate to be responsible for individual right compliance. So individuals have actually a lot of rights over the protected health information. They can request accounting of all of the disclosures of their data. They can request to amend their data. They can request to get a copy of all the data of theirs that you have. And some covered entities will actually contract that responsibility out to the business associate and put that onus on the vendor to give that information to the individual. So if that's not something that you can comply with, make sure that you put that onus back on the covered entity. You can, of course, provide them reports that they need, but they should be, responsible ultimately for responding to the individuals if you can't comply with that. Finally, sometimes you'll see, like Stacey mentioned, auditing requests, right? So they want to be able to audit all of your policies and procedures. Under HIPAA, the only entity that has that right is the Department of Health and Human Services, not the covered entity. So you do not have to comply with that with respect to the covered entity. And finally, I would say that some BAAs will actually have a provision requiring you to be HITRUST certified. If you are not HITRUST certified, be on the lookout for those provisions. Because if you aren't HITRUST certified and a breach happens, you'll be responsible for that breach, for not being in compliance with that as well. So that's kind of what I had on business associate agreements and kind of the significant provisions that are able to be negotiated. I think that, Stacey, unless I'm wrong, we can open it up for questions now, whether they're on the state and federal side or they're on the HIPAA compliance obligations.
Yeah, we're happy to answer any questions. I know we're pushing up on time for the session, but we can certainly stay after. I think the session stays open a little bit after, so we can certainly stay after and answer questions. I think you can also find Caroline and I's contact information in the materials provided with the conference materials. And so feel free to reach out to Caroline or I at any time with any questions. We love chatting through. We're kind of geeks with respect to our privacy rules. So we'd be happy to chat through any questions or comments on the privacy rules and the information we provided today.
And one thing I might point out too, as I kind of wait for questions to come in, is getting form agreements for all of these things is really important. It allows you to keep track of what your obligations are with respect to your clients, so that it's easier to keep track of a couple exceptions to your forms rather than having to keep track of all of the different rules under each agreement that you've signed with all your clients. So I just want to throw that out there as well. And I see you have a question come in, and it looks like it's for Stacey. So I'll go ahead and read it, Stacey, and then you can give us your expertise. How do these legislations apply to Nebraska small business websites that don't necessarily deal with California or Europe? And what about hospital websites?
Yeah, so great question. So it really comes down to what information you're receiving. Are you receiving information of data subjects that are located in Europe or in California? You may not qualify as an entity yourself, a Nebraska entity that's only operating in Nebraska, but if you have customers and you're getting data from those customers that have far reach to Europe or California or some of the other nations that are enacting these laws, you could see flow down obligations that come out of that as a processor or as a service provider under those rules and regulations. Generally, though, I'd say if you're operating in Nebraska, and you're just doing business in Nebraska, then your risk with respect to application of those rules is very slim. There are threshold annual revenue requirements under CCPA. Those apply to the controller. So again, you'd only see them as a service provider if they flow down. With respect to, just your website, as a federal rule, if your website's available for persons outside of Nebraska, which really any website is in today's world, and you do get traffic, for persons outside of Nebraska. So as long as your website isn't targeted specifically only to Nebraska residents, if it's about, a restaurant that's, if you own a restaurant and that's your website and you only have, your website, your restaurant in Nebraska, maybe you have takeout or delivery, but it's only Nebraska. I know this isn't a tech company example, but your operations are here. There's no one outside of Nebraska, that you would think would visit your website. Then things like a privacy policy or some of those other federal rules wouldn't necessarily apply to you. But as soon as your reach gets outside of Nebraska, you have visitors or traffickers that are outside of Nebraska, then some of the basic rules, the requirement to have a privacy policy on your website, and some of the other kind of just general federal rules that we've seen from the FTC would apply to the operations of your website, but not necessarily those overarching rules, GDPR, CCPA. That, just to kind of reiterate, is about the data resident information that's being collected. So only if EU resident information or California resident information was involved.
So, and I might touch on the hospital website question, Stacey, just briefly. If you are a healthcare provider, so if you are a hospital, HIPAA will apply to your website to the extent that you are collecting or disclosing protected health information through the website. So, for example, if I'm a hospital and I have testimonials from various patients about the services that they received from X physician. If I'm posting those testimonials publicly on my website, HIPAA applies to those testimonials. And so you'll have to have either individual authorizations to post those, or you'll have to be otherwise in compliance with HIPAA, have some other permissive use or disclosure rule that applies to be able to advertise those things on your website. Another way that it could apply is if you have a hospital website that has a patient portal where the patient can log in and see, for example, the results of various tests that they've had done, when their next appointments are, prescription numbers, things like that. If that's all within the patient portal on the website, all of that data, of course, is also going to be subject to HIPAA. The website itself, with respect to the patient portal, will be subject to HIPAA. And so you do need to comply with respect to that data that's collected and maintained there. I hope that answered your question. So I don't see any other questions coming in. Of course, you're welcome to reach out to either of us. We're both attorneys at McGrath North. You can easily find us if you do have data privacy questions. But otherwise, thank you guys so much for your time today. We really appreciated speaking at this conference. It was a great opportunity, and we've enjoyed hearing all the other speakers at other breakout sessions as well.
Thank you, everyone.